Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Bellomo, where we discuss all things estate planning and elder law. And well, hey, anything else we want to talk about. Today is going to fall squarely under the estate planning and elder law category, as we are going to talk about a potpourri of items directly related to estate planning and elder law. We're going to talk about some IRS rulings that have come out this year. We're going to talk about updated tax numbers, updated Medicaid numbers, as well as some miscellaneous estate planning tidbits. And most of them are coming, and we're doing them in one show because this is a conglomeration of a lot of the questions that we've been getting lately over and over again. So clearly it's out there sort of in the mainstream, and people are reading articles, they're listening, they're hearing things about it, which is awesome. But I thought I would address it in the podcast to kind of kill several birds with one stone. And, you know, for our maintenance families within the Bellomo law firm, every week I am on a Your Legal Hour where I'm talking to our clients in real time, getting questions from them. And these are questions that keep coming up. So I figured I would address them in the podcast as well to get it out in general consumption. So I look forward to this one. This is going to be a fun one, a bunch of different topics. I'll explain what they are. I'll explain the significance of them. But in perfect fashion, none of them are negative for what we're doing at Bellomo and Associates. None of them are negative to what we're teaching. None of them are contradictory. In fact, everything that has been coming out is directly in line with what we've been saying and what we've been teaching. So it works out very well. I'm sure there will be a day where, a new ruling will come out and we'll have to pivot to the left or pivot to the right. But for now, everything is exactly as we want them to be, which is a big reason why I wanted to kind of handle this all in one podcast to get the word out there. Just a reminder, please don't take anything you take from this show or any other show for that matter to constitute legal advice. If you're looking to receive legal advice about a specific situation regarding you and your family, please get a lawyer in the state that you are a resident of who practices in the area of law that you are looking to receive advice in. Then and only then can you get an attorney-client relationship to provide legal advice for your specific situation. This show and any other show should be for informational, education, and entertainment purposes only. At Bellomo and Associates, we educate on a weekly basis. We have estate planning workshops. In these estate planning workshops, we talk about financial powers of attorney, medical powers of attorney, living wills, last will and testaments, and we talk about trusts. We cover the gamut from revocable trusts to irrevocable trust to asset protection trust to pure grantor trust to all different kinds of trusts to explain what is allowed, what you can do, and how they work. We also have educational workshops in crisis planning. If you or a loved one is going to need long-term care in your home or in a nursing home in the next, say, less than 6 months or 6 months to a year, please come to one of the Medicaid crisis workshops to learn what options are available in the state of Pennsylvania in crisis. We also offer life care planning workshops. Our social worker, Meg Monner, provides these workshops to explain why it is important to have a client care advocate on your side and on your team to answer the non-legal questions like, is it safe for me to be at home? Is it safe for mom? What renovations can we make to the home? When is it time to go to an assisted living? When is it time to go to a nursing home? For a holistic approach to estate planning, we offer life care planning to be able to provide for those non-legal issues that I frankly don't know the answers to, but certainly Meg does. When a loved one passes away, we offer administration workshops for probate and trust. So if a person had a will or didn't have a will, that would be probate administration, or if they had a trust, that would be trust administration. We offer all education at Bellomo for free, and we also offer special needs workshops. if you or a loved one is disabled and receiving public benefits, you want to understand what the different types of trusts are, meaning first party versus third party versus pooled trusts versus able accounts. The bottom line is we will educate you on all those types of trusts, when you need them, when you can do them, when you can't do them, and what they're intended for and what the purposes are. If you're looking for that type of education, please call us at 717-845-5390 or check us out on the web at www.bellomoassociates.com. All right, so now we're into the podcast today. We are in 2024, and so what I wanted to do first and foremost is to give you the updated tax numbers and also the Medicaid numbers. So from a federal estate tax perspective, currently in the year 2024, the federal estate tax limit is now $13.61 million a person. And if they are married, another 13.61, which I believe is 27.22, if I'm doing that math correct. And what that means is an individual can pass away with having 13.61 million and a married couple 27.22 million, or have given away that during their life and then at their death. And as long as they don't exceed that amount of money, there will be no federal estate tax. And I believe the current federal estate tax exemption is still 40%, which means anything above that would be taxed at a 40% tax rate. Now, for most of our clients, in fact, all of our clients, we don't have clients typically locally here in the York and Lancaster area that have more than that kind of wealth. In 2026, the federal estate tax limit is set to come back to $5 million plus inflation. From what I'm reading, we're expecting that to be around $7 million a person, which would then make a couple at $14 million. That would certainly bring some more people into play, but generally speaking, for this area in York and Lancaster, Pennsylvania, generally speaking, most people will not have a federal estate tax problem, even if it comes back down in 2026. Now, you're hearing all kinds of rumors, right? But the truth is, nobody knows whether anything is going to change or not. And I say that because we don't know who's going to win the election. I think that depending on who wins the presidency as well as Congress, Senate, and the House, that will determine whether we see it changing. Now, the thing to remember is the tax law is set, never to have to be touched again, and it goes back and then it's set for inflation. So the significance of that is that if we have a divided House, or we have a divided political parties in the areas where we would need it to all be kind of on the same page to change the law because of the rules, you might see it not change, which means it would come back, but it would be set for inflation. What I always advise is, particularly when you're dealing with tax planning, don't do it until you have to. And the reason I say that is because the only way essentially to not be taxed from a federal estate tax perspective is to give up control. And as you've heard from all of our radio shows and podcasts, control is what estate planning is all about. Control and access. So if you don't have to give up control, meaning if you don't have to do a federal irrevocable tax trust where you have to give up control, you can't be the trustee, you can't be the person who has any say, you can't change it, you can't modify it, you're not going to want to do that until you absolutely, unequivocally have to. And you don't have to currently unless you have more than 13.61 million. And if you're married, your spouse has more than 13.61 million. So for most of us, we're not doing that planning currently. In 2024, the annual exclusion gift is currently at $18,000 a person. So just a reminder, husband and wife can give $18,000 to son and another $18,000 because son is married to wife. So that's 18 and 18 for 36. Husband can do the same. 36 and 36 is what? 72. Then you also have, if there's another child who's married, it's another 72. So what is that? 144, whatever that number is, that is per year. So that tends to be a significant amount of money on a regular yearly basis, in addition to the 13.61, in addition to the additional 13.61. So that is a significant amount of money that most people don't even have. So therefore, they don't really need to rely on the annual exclusion gifts currently. Whether you should file a gift tax return is something you should discuss with your attorney and your tax preparer, whether it's necessary, whether it's needed. There's some thought processes that go into that. Will certainly be above this podcast today. But for today's purpose, just a reminder, 13.61 is the federal exemption amount in 2024, and $18,000 is the tax exemption number. The Medicaid numbers also came out here in Pennsylvania. I'll do a quick rundown mostly of the major numbers that apply, the major numbers that we have to focus on. Some of these just recently changed. So for Medicaid purposes in Pennsylvania in 2024, we are going to be using an income of $2,829. And that number is significant because if your income on a monthly basis is greater than that, then you're only allowed to have $2,400 in resources. If it is less than that, $2,829, then you can have $8,000 in resources. It's also significant because it is the income cap limit amount. So what that means is if a person is trying to get waiver services in the home for long-term care in Pennsylvania, Pennsylvania has an income cap limit of $2,829. Now, as we've talked about in other podcasts and shows, there isn't a little wiggle room there with a $500 sort of bump on top of that. So if your income is greater than $2,829 plus $500, you will not be eligible for waiver services. But my advice is to talk to somebody because there are exceptions. There are certain ways around it, but generally speaking, $2,829 plus $500 is the cap. If you're anything under that, you definitely want to talk to a professional to discuss whether you can qualify. All right, now, when you're talking about protected share amounts, we always say community spouse, right, can keep the community spouse retirement account, a car, and then half of the pot, no more than $154,140, no less than $30,828, plus a house. So the significance here is the minimum and maximum numbers went up. The maximum amount is half, but no more than $154,140, no less than $30,828. So that did go up. The penalty divisor amount actually came down a little. So when we're talking penalty, when we're talking how much is a person going to be penalized and what is the waiting period going to be for them to qualify, it is how much did they give away divided by 379.65, right? Or divided by 11,547.69 a month. So it was actually a couple grand higher than that last year. It is now back down a little bit, which means the divisor amount, you take the amount gifted divided by the daily penalty rate, and that tells you how many days there's a penalty before a person qualifies for Medicaid. Just a reminder, there is no such thing as a 5-year penalty, right? It's a 5-year look back, which means we're looking back 5 years. We're looking in the box to see the statements of all of the assets to determine what gifts were given, and then the penalty amount is based upon 379.65 daily. The maximum triple MMMNA, which is the maximum monthly maintenance needs allowance that a spouse is allowed to have, and now we're talking income, the maximum is $3,852.50, and the minimum is $2,465. So I believe the minimum was from July of last year. The maximum recently changed to $3,852.50. The excess home limit is $688,000 as the minimum and $955,000 as the maximum. The home maintenance deduction is $965.10, and the heating standard effective October 1st was $750, and the non-heating standard was $401 effective October 1st as well. The personal needs allowance is still $45. So That is the Medicaid numbers for 2024. If you're listening to this wondering what the heck all of that means, no problem. Please come to our Medicaid Crisis Workshop. It is offered on a regular basis. We have links to it so that you can watch it. And because the numbers are constantly changing, I like to put out the updated numbers because it's very difficult to change all the workshops that have been recorded previously, simply because we're offering them on a regular basis in-house. And so I like to do updates like this to update when the numbers happen. All right, so some other things that I may have touched on in other podcasts that I just kind of want to have all in one location. We're getting a lot of calls. In January of this year, the IRS put out a revenue ruling, and a lot of newspapers and organizations picked up on it. And the headline was, "Children Lose Stepped Up in Basis with Irrevocable Trusts." That's the headline. And so people are freaking out because they're worried about the fact that we're losing stepped up in basis. And that is not the case with the trust that we use at Bellomo and Associates. What I mean by that, one of the things that I've been saying for years is that the value of the trust that we use is that they are pure grantor trusts, which means that they are included for income and estate tax purposes. We abide by all trust principles and tax laws. So why that's important is because I'm not worried about a government agency or someone coming back later and saying, look, you can't do this. And one of the examples that I have been giving for over 15 years is that for some reason, and I'll never completely understand it, there was an animal that was created that was called an intentionally defective grantor trust that was excluded for estate tax purposes, but included for income tax. Now remember, the trust we're using are pure grantor trusts for income and estate. This one was excluded for estate tax purposes, meaning it did not count against a person for like inheritance tax purposes, right? It was not included for estate tax purposes or for inheritance tax purposes. But by that definition, then, the children should not get a step up in basis. And what I mean by that is if dad buys a house for 20 grand and dad gifts it to me, my basis is 20 grand. If I later sell it, if the fair market value is 200 minus 20 is 180,000 subject to capital gains tax. If dad puts it in a trust that he controls, it's included for inheritance tax purposes. I pay the 4.5%, but I get a step up. So now the value to me is 200. 200 minus 200 is 0. But for some reason, the IRS allowed people to use these intentionally defective trusts, excluded for estate tax purposes, and then still gave the children a step up in basis. It makes no sense. It completely defies tax law. It completely defies everything we know about trust principles. And finally, the IRS stopped it. They put their foot in, they stopped the loophole, and they're not allowing it anymore. The problem is that the headlines didn't say that. It just said, irrevocable trusts lose a stepped up in basis for children. That's not the truth. That's not the case. That certain type of irrevocable trust lost a step up in basis, but not all, and not the ones we use. It has no impact. So if you have a trust with our office, please, it will not be impacted by that revenue ruling. And furthermore, if you're thinking about doing it, that is not a reason not to do it, because it truly is not an issue. It is not about the types of trust that we use. It has zero impact on what we are doing at Bellomo and Associates. So I don't like that those headlines are that way. I understand why they write them. They do it for, if it's online, they do it for clicks. If it's in a reading, they do it for people to buy magazines. I get it. But you have to understand the why behind it before you get concerned. Also, recently, Governor Shapiro in Pennsylvania finally adopted the grantor trust rules to mimic the federal grantor trust rules. So this is huge. Again, not impacting what we're doing, not impacting many of our clients. I have always said, talk to your accountant preparer to determine what best for you to do in Pennsylvania, whether you should be filing PA 41s. That means that if you had been filing, you will not need to be filing in the future, and everything is status quo. So they finally adopted all the federal grantor trust rules. So we are good to go. Everything is what we've been teaching. Everything is right on spot, right on target. So like I said, if you're working with an accountant who was filing those trust tax returns, please touch base with them, see whether you have to file another one, and then you won't have to file ever again moving forward because of Governor Shapiro adopting the federal grantor trust rules. We kind of expected that this was only a matter of time. To my knowledge, we were the only state in the country that didn't adopt that, which was very awkward to have a situation where the federal rules were different than the Pennsylvania rules. I think it might have something to do with why the enforcement wasn't high on it, because it was contradictory. But Governor Shapiro finally adopted the federal rules. So basically, we are good to go. The federal rules, Pennsylvania rules are all the exact same. All tax consequences will be borne by the grantor, the person who created it, which is exactly what we want. We want all tax consequences borne. As I mentioned earlier, these trusts are included for estate and income tax purposes, which is exactly what we want and what we want the tax consequence to be. So business as usual. We do not have to file separate state returns moving forward. To the extent that you will not have to, and we won't have to file them moving forward. So that is a good thing. Recently, the IRS announced a potential gift tax consequence to trust beneficiaries. So I also wanted to mention this. This has nothing to do with the trust that we do. Essentially, what we're dealing with here is when you have a grantor and they are allowed to pay out of the trust the tax consequences. Because the tax consequences are borne by the grantor is allowed to use the money out of the trust to pay the taxes. The case that this is about is not about a case where somebody did it. You're allowed to create it. You're allowed to keep that right. And there's no tax consequence to anybody for you having that right. The case facts were that the original trust did not provide for it, and they modified the trust with a court order. And when they modified the trust with a court order with consent of all beneficiaries, as state laws require, the state allowed the modification, which changed the trust terms to grant the trustee discretionary power to reimburse the grantor for income taxes paid by the grantor as a result of the inclusion of the trust income in the grantor's taxable income. That's what we have in all of our trusts. That's allowed. The IRS concluded that because you added the power to reimburse, it would then therefore involve a relinquishment of the portion of their interest in the trust. Therefore, the gift should be valued in accordance with the state gift tax regulations, meaning there was a gift then because of that change. Now, that is not what we're doing, because we're allowing it from the very beginning, and therefore there will not be a gift tax consequence to the beneficiaries, right? So I wanted to bring it up because a couple people have found it and they're all freaked out about it. And does it mean that there's going to be a tax consequence? No. We are creating this from the beginning. The only time this could become an issue is if you are later amending the trust if it didn't provide for it originally. Our trusts allow for it from the beginning. No problem whatsoever at all. Not changing what we're doing, not changing how we're doing it. It's exactly, we are good to go. You are allowed to have that right. There will be no tax consequence to your beneficiaries because we're allowing for it from the creation of the trust. So we are good to go. One of the other most recent things that has been coming up is that there was a law that was put into place very, very recently about reporting requirements of different trusts. And basically what it's saying is FinCEN, FINCEN, expects that if you have a trust, and if the trust was essentially created by a certificate from the state, you have to do a filing requirement. It's a BOI filing requirement. We have done tons of research. It just went into effect literally within the last couple days. And it is essentially saying that BOI reports are required. And the website is FinCEN, FINCEN.gov/BOI. So they're BOI reports. But the trusts that we use are not these trusts at all. Like they're not issued by a certificate from the state. They do not meet this requirement. We do not have to file. And I'm just putting it out there because this is not regarding the trust that we have, and therefore it is not something that is needed to be done. They do acknowledge in the articles and on the website that FinCEN recognizes that many states, the creation of most trusts typically does not involve the filing of such formation creation documents by the state. So they're even acknowledging that most states this won't apply. The problem is I think what happened was when accountants were going for their education before tax season started this year, a lot of the educational entities were really focused because it was brand new. There was a lot of talk about whether the attorney should be filing, whether the accountant should be filing. So I've gotten a couple calls from a couple of accountants that we work with and a lot of clients who are freaking out about it. And I just want everyone to know that the trust that we use at Bellomo and Associates does not meet that requirement. It is not something that will have to be done. I believe it's a financial crime reporting thing that they're trying to do to make safe, and I get it. But the trust that we use in Pennsylvania, they're not being issued a certificate by the state, and therefore do not fall under this reporting requirement, and therefore it's status as usual. So today's podcast, I think the lesson is that luckily nothing has changed that is negatively impacting what we're doing, the way we're doing it. We talked a little bit on this podcast about the most recent estate tax limits, the Medicaid numbers for 2024, a little bit about grantor trusts and how we still get to step up in basis for the trust we're using. We also are fine as far as retaining powers by the grantor and the trust to be able to pay the tax out of the trust to reimburse the grantor for their personal income tax filings. And that will not be a gift from the beneficiary to the grantor because we're creating that from the very beginning. We're not modifying it. It's already provided for. It's already allowed. And then finally, the new reporting requirements under FinCEN, FINCEN.gov/BOI. Those BOI requirements are not something that our trusts will need to file reporting for because these trusts were not issued by a certificate of the state of Pennsylvania. So therefore, it does not apply. And the FinCEN site even specifically says that most states' trusts are not created this way and therefore would not have to file. So we don't have to worry about that either. So good news all around as far as the update for 2024. I hope this was an informative show. I really appreciate you joining me on the Red Wagon Estate Planning and Elder Law Show. I am Jeff Bellomo, and I cannot thank you enough for your time. I look forward to seeing you at one of our upcoming educational workshops. I hope you enjoyed this podcast, and until next time, we'll see you real soon.